Broadcast is now starting. All attendees are in listen-only mode.
Hello, my name is Kelly Tebow. I'm with the New Jersey Center for Tourette Syndrome and Associated Disorders, and I will be your organizer for this evening and would like to welcome you to our webinar on IDEA and Section 504 of the Rehabilitation Act of 1973, What Every Parent Needs to Know. Thank you for joining us. Before I have my colleague introduce the speaker for tonight, I'm going to cover some housekeeping items with you. All participants are muted. If you have a question, please type it in the bottom of your question box and click send. You may send questions during the webinar, however, we will have Ms. Greenwald answer the questions at the end of her presentation. We will get to as many queries as time allows, and in addition to tonight's presenter is available to take your questions on the Wednesday webinar blog, which is accessed from our homepage under the heading Programs. This blog will be monitored for the next 7 days. Feel free to look and post questions as often as you like. Answers will be archived for future reference. If you missed part of the presentation or would like to watch it again, an archived version will be posted to our website shortly. We value your input, and in order to expand the webinar experience in the future, we need everyone to fill out the survey as you exit the webinar. The New Jersey Center for Tourette Syndrome and Associated Disorders, its directors and employees assume no responsibility for the accuracy, completeness, or objectivity or usefulness of the information presented. We do not endorse any recommendation or opinion made by any member or physician, nor do we advocate for any treatment. You are responsible for your own medical decisions. Now, I'm going to turn over the introduction of our speaker to Martha Butterfield, the webinar coordinator of NJCTS. Marty?
Thanks, Kelly, and good evening, everyone. Thank you for joining us. Our presenter for tonight is attorney Staci Greenwald. Staci is and received her She is admitted to practice in all New Jersey courts, the United States District Court for the District of New Jersey, and the United States Circuit. She's also a frequent lecturer throughout New Jersey. Staci, we're so pleased to have you join our webinar family. And now, without further introduction, I'll turn tonight's program over to you.
Thank you very much, and thank you for that great introduction. I would just like to say before I start the actual presentation that I practice in New Jersey, so any information that I'm giving you is going to be New Jersey specific. You need to make sure that if you're from another state that you check your state's code, because while the Individuals with Disabilities Education Act and Section 504, the Rehabilitation Act of 1973, are both federal laws, the IDEA is procedural in nature, and it leaves up to each individual state how they're going to implement those laws. So there are some differences between states, so you want to make sure that you do check with your state. Tonight, I'm going to give you a brief historical overview of the law, and then I'm going to review some of the salient areas that have been impacted by recent amendments. I'm having technical difficulties here. I apologize. For some reason, my screen is not moving, so this is going to be a problem.
I was going to say, click on your slide and then use your
federal law, and it started with Public Law 94-142, which started as the Education for All Handicapped Children's Act of 1975. And the law mandated for the first time that parents be equal partners in making educational decisions for their children. It empowered parents to become educational advocates. So, understanding what Congress envisioned when it enacted the law gives us some idea as to what our roles are in providing services. It talked about improving educational results. It talked about independency in my second bullet, as I said, with public acted into the IDEA law itself. And it talks about now and requires that an IEP contain a statement of transition service needs. It used to be at age 14. And it needed to be updated annually to ease and support the transition from public school and IDEA programs in public school to education, employment, and independent living after the student left public school. So in 2004, it changed the timing so that we're now talking about providing those transition services with the first IEP after the child turns age 16. And again, talks about that post-secondary planning. It also went on to modify the purpose or improve the ability to go on and do wonderful things in life. And I say our kids, not just because I'm a special education attorney, but because both my kids went through special education as well. And, you know, what I knew about my kids and what I know about the kids that I deal with is that a lot of them are really, really bright and really, really capable. And finally, in 2004, the IDEA acknowledged and realized that maybe our kids learn a little differently, but they are capable of going on to further education. So that was wonderful to see. Some of the other goals, we want to give every child who meets the law's definition of a child with a disability is entitled to a FAPE in what we call the least restrictive environment. As part of FAPE, a child with a disability is entitled to special education. This must be individually designed to meet the unique needs of the student and prepare the child for further education, employment, and independent living. The program must provide for significant and meaningful educational benefit. The child is also entitled to related services. Special education and related services is what the child is entitled to. Prior to 2004, the child, in order to be eligible for special education, needed to either require special education or related services, and now it's special education and related services. And the related services is a broad definition, and it's not meant to be all-inclusive. It includes transportation, speech, occupational therapy, counseling. They're entitled to related services that will enable the child to benefit from their educational program. It also talks about enabling the child to be educated in the least restrictive environment. Now, the New Jersey Administrative Code, and again, for those of you who don't live in New Jersey, your administrative code is going to talk about what your least restrictive environment is. But in New Jersey, section 6A:14-4.2 says that to the maximum extent appropriate, a student with a disability is educated with their non-disabled peers, and that separate classes, separate schooling, or other removal occurs only when the nature and severity of the educational disability is such that education in the regular class with the use of appropriate supplementary aids and services cannot be achieved satisfactorily. Now we'll get on to what appropriate supplemental aids and services are in a little bit, but that's what the child is entitled to under free appropriate public education. We talked about the least restrictive environment, which is defined as the environment closest to home where progress rather than regression or stagnation will take place. We can only have one least restrictive environment while we can have more than one appropriate placement. So in order for a program to be appropriate, least restrictive, not only does it need to be appropriate first, but it would be the one closest to home. So if we have two programs and one is appropriate and one's not appropriate, even if the one that's appropriate is further from the child's house, that becomes the least restrictive environment. It's the environment closest to home where that child is going to be able to make significant and meaningful educational placement. So what is placement? Placement is the appropriate learning environment for your child. And as we talked about before, the IEP team must consider placement in the regular education setting first. That doesn't mean that the child necessarily has to attend a regular education setting, but it needs to be something that's considered. For some students, it's clear from the outset that a regular education program is not going to be appropriate, but we at least need to consider whether it's going to be. And we have a number of things that can be done in terms of placement, and we have a continuum that we look at, and we go down that continuum to determine what is or is not appropriate for the child. So we start with modifications within the regular education setting, which is a change in the type and amount of work that's expected of the students. And then we talk about accommodations. It changes how the student learns and the way they demonstrate what they've learned. Now, this is where we get into a difference between Section 504 of the Rehabilitation Act of 1973 and the Individuals with Disabilities Education Act. If a student requires a 504 plan, we're talking about providing modifications and accommodations. When we talk about an IEP, the student requires special education as well. So that is one difference, and we'll talk about it a little later. We have other things on the continuum that we look at. We talk about the mainstream class with curricular or instructional modifications. We can provide assistive technology, teacher aids, related services, integrated therapies. These are all things that can be provided as part of a FAPE for your child. We start with in-class resource programs, which is where we have 2 teachers in the classroom, one of them being a special education teacher, one of them being a general education teacher. If the team determines that in-class resource is not appropriate, we can look at a pull-out resource center program. From there, we look at self-contained classes, and we have a variety of those ranging from kids that have behavioral disabilities and emotional disabilities to children with learning disabilities or cognitive impairments. It runs the gamut. We then have New Jersey approved private schools for students with disabilities, and then we have non-approved but accredited private schools. And then finally, we have home instruction and residential placements. And these are all set forth in the New Jersey Administrative Code. So what happens and how do we go about locating, identifying, and referring a student to determine whether they're eligible for special education and related services? There is a difference between child find and referral. In some cases, before a student is actually referred to the child study team for evaluation, we do something called RTI, response to intervention, or we try what we call intervention and referral services, which is where the student is identified as a child who may be in the future or currently eligible for special education and related services, and we provide supports for that child before we actually go on and evaluate that child. When that doesn't work, or we find that the child is not benefiting, then we go on and have that child referred to the child study team. A direct referral to the child study team has to be made when a parent requests an evaluation, when the student is not responding to the interventions, or when it's clear from the outset that a referral is warranted. And I just want to go back to the INRS. There are kids who are receiving special education through, reading services. Anything that you can do through an IEP, you can actually do through your INRS. But if it's not working, then we want to go ahead and we want to refer that child to the child study team. Who can refer a student? Any member of the school staff, including teachers, the parents, any outside agency. You always want to make sure that the referral to the child study team is done in writing. It should be addressed to the Director of Special Services, and it should be dated and explain the nature of the student's disabilities and indicate that you're giving consent for the student to be referred to the child study team and why you're making that referral. It's always helpful to indicate, the types of issues that you're seeing, because the more information that you can provide, the better the team's going to be prepared to determine whether evaluation is going to be done. A lot of times a parent will have an outside evaluation done, and the law says that all non-district reports must be considered. However, there is nothing in the law that mandates that the reports be accepted. So a school district has to look at it, and they can accept part of it, they can reject part of it, and they can decide what they're going to use or not use. The school district has 90 days to do their evaluations. Prior to actually sitting down and having the evaluation meeting where you go over the evaluations to determine whether the child meets the criteria and is going to be found eligible for special education and related services, the school district has to provide you with the reports at least 10 days in advance. Once the evaluations are done, they then sit down and determine whether the child is going to be eligible. If the child is eligible, then we're going to go on and determine what that IEP is going to look like. So if at the eligibility meeting, the child is determined eligible, then the school district has to provide you with the team's determination in writing. You have a right to bring anybody you want with you to the eligibility meeting and actually an IEP conference. I will tell you that if you're going to bring an advocate and or an attorney, most of the time, if you're going to bring an attorney, the school district is absolutely going to have their attorney there. Most of the time, if you're going to bring an advocate, then the school district is going to have their attorney there as well. You have a right to tape record that meeting, and you have a right to ask as many questions as you want or need to in order to determine and decide whether you understand the reports that are being provided by the school district. So when we do evaluations and we're looking at initial eligibility, the law talks about doing at least 2 evaluations. The child study team, in all likelihood, is going to look at and do a social evaluation. They're going to do a psychological evaluation, and they're going to do an educational evaluation. When we determine eligibility, the law talks about evaluating the child in all areas of suspected disability. And this is where I find that we have a lot of problems. Sometimes a child will have Tourette syndrome, or they'll have ADHD, or they'll have emotional issues, and the school district will sit down, and when they do their evaluation plan meeting, they'll talk about doing a psychological evaluation and an educational and maybe a speech and language, but they don't talk about doing a psychiatric evaluation. They don't talk about doing a neurological evaluation. They don't talk about doing an auditory processing evaluation or an audiological evaluation. In order to determine whether a child is eligible, we need to evaluate that child in all areas of suspected disability. So you as a parent have a right to say to the school district, listen, I think my child has ADHD. I think my child suffers from an auditory processing disorder. I would like the district to pay for an evaluation in that area. And the school district, if they're going to evaluate in all areas of suspected disability, should be agreeing to do those evaluations. Who is eligible under the IDEA? So it is a 3-pronged test that we look at. The child has to have a disability. The disability needs to adversely affect educational performance, creating an educational need, and the child must be in need of special education and related services. So when we look at eligibility, and there are 13 categories in New Jersey, and I'm going to show you them in a minute, but having the disability itself isn't enough. It's the adversely affecting educational performance, creating an educational need. What we find sometimes is with a lot of our what we call 2E students, twice exceptional, kids that are really, really bright, but also have learning differences or may have other disorders that impact their ability to function in the classroom. We find sometimes that we have a dispute over whether there is an educational need because the child is functioning maybe in the average range, but because of the child's innate intelligence, that child should be functioning much higher. And the school district is arguing that there's no educational need. The other thing that we need to look at is that a child must require special education and related services. And this is really the difference between our 504 kids and our special education students. Our special education students require that special education, while our 504 kids are the ones that just require the accommodations and modifications. So what is an educational need? An educational need requires that the child show evidence of need of special education services by an inability to progress in a regular education program. But again, education need is not limited to academics. Education is a broad concept and includes a lot more than academics. It's social skills, it's toileting, communication, emotional functioning. A lot of times I see one of the areas that we run into problems is children with emotionally based issues whose academics are absolutely fine, but emotionally they have difficulty functioning in the classroom. They may get easily frustrated if something is difficult. They may have behavioral issues. They may have school refusal. They may be impulsive or distractible. Those kids may require social skills instruction, executive functioning. They may need refocusing by their special education teacher. They may need things broken down. That's an educational need, and it doesn't matter that the child may be academically at or above grade level. If it's impacting their ability to function in the classroom, it's an educational need and should be addressed. So what are our IDEA disability categories? I'm not going to read these because you guys can read them yourselves, but these are the areas that would qualify a student under the IDEA. And when we determine eligibility, we have to fit our students into one of these categories. I should note that if we look at preschool, children with preschool disabilities, all students between the ages of 3 and 5, no matter what their disability is classified as preschool disabled. And that has its own innate issues because when we classify all students under one category, sometimes the lines get blurred in terms of what kind of program is or is not appropriate. So let's talk about this a little bit more. What happens when the student is found eligible for special education and related services? What we do is we write an IEP, an individualized educational plan. And it is a plan designed specifically between your child, between the school and the parents, outlining how the student is going to be educated. It is the blueprint of special education. And it tells us what kind of services, what kind of programs, what kind of accommodations and modifications the student is going to get. The IEP must address the children's academic, functional, including non-academic needs related to behavior, social and emotional functioning, and life skills. Because as I indicated before, the IEP and education is not just academics. And it has a variety of areas that we need to address. And I'd like to just pinpoint some of them. If you go to, at least in New Jersey, the New Jersey Administrative Code, and you look at section 3.6, that's where we talk about the IEP itself. But we want to make sure that the IEP details accommodations that the necessary contain the transition services. And again, when we talk about the accommodations and modifications that have to be in the IEP, those are the same accommodations and modifications, or could be the same accommodations and modifications if you're going to get to a 504 plan. So any student that is IEP eligible, by definition, is 504 eligible. We just take those 504 accommodations and we put them into the IEP itself. When we talk about the IEP, and I see this as one of the biggest issues, the IEP is supposed to talk about what the school is going to do for the child, not what the child is going to do. So if one of our goals is for the child to seek out help when he needs it, that's a great goal, but how are we going to teach that child to seek out that help? What the school is going to do for the child, not what the child is going to do. And the IEP also has to address all of your child's school-related needs, not just those for which he or she has been referred. And this would include behaviors that occur at school. So it's a requiring that at the beginning of the school year, the IEP for every student who's receiving special education and related services. This is very important. A lot of times teachers haven't seen the IEP and don't know what is required. You need to make sure you ask your teachers, including the special teachers, if they've seen the IEP. If they haven't, go ahead and give them a copy. Very, very, very important. So what are we looking at in an IEP? Oh, I'm sorry. one more before I get there. The IEP also requires that every student's IEP be accessible to each regular education teacher, special education teacher, related service provider, and other service providers who's responsible for implementation. This is really important as well, because if a teacher doesn't know that your child has an IEP, how are they going to provide the appropriate supports, services, and special education that the child requires? As I always like to say, a child's needs don't end when they leave the regular education classroom. They follow that child throughout his entire day, and therefore it's important that all teachers know what's going on. So when we talk about the IEP, one of the main sections that we want to make sure is done correctly is what we call the present levels of academic achievement and functional performance. And this should describe what the pupil can and cannot do and answer these questions. What does the student most need to be taught? Where should instruction begin? What learning characteristics of the pupils must be considered? And it has to address the social and emotional needs. It must be written in objective and measurable terms. So often I see IEPs that say, you know, the child is reading at about the second grade level, or the child is very friendly. We really want to get specific here. You know, Angie was given the Fontes and Pinnell, and she is reading at a level K. She was also given a reading comprehension test, and she scored at the 2.4 grade level. You know, in unstructured time, she is distractible and impulsive and needs to be refocused. It should also contain, however, your child's strengths, because it's important for all teachers to know not only what your child has difficulty with, but what the child really does well at, so we can use the child's strengths to help remediate some of those weaknesses. From the present levels of academic achievement and functional performance, we want to then develop the annual goals. And the annual goals not only include the academic and functional goals to meet the child's disability-related needs and enable the child to progress in the curriculum, but it also needs to meet the needs of the child that result from the child's disability. They have to be detailed and apprise you as parents and special education service providers of the expected level achievement for each goal. Even though it should detail and apprise what we're expecting the student to do or achieve within a one-year period, it is not a performance contract. You cannot say just because a student didn't meet all of their academic goals or any of their non-academic goals that the school district has failed to provide an appropriate educational program. But clearly, if, you know, at the end of the year the child has not, we certainly want to sit down and figure out what went wrong and how we change things so that the child is going to make significant and meaningful educational progress. The other section that I want to talk about is the short-term objectives. And they're the intermediate steps between where the child is now, as measured by their present levels of academic achievement and functional performance, but where we want that child to be at the end of the one-year period. So these are waypoints. And as I said before, the IEP is the roadmap to special education. So if we look at this as a roadmap, we really want it to be detailed. Giving an example, and I had a learning consultant that I had worked with years ago, who gave a wonderful roadmap example where he talked about the fact that if I said to you that on November 13th, 2009, I'm here, and on November 18th, 2020, I want you to be over there, the I'm here is the present levels of academic achievement, and the annual goal is for you to be over there in a one-year period. It's not very detailed and nobody knows what you're talking about. But if I said to you that on November 13th, 2019, I'm at exit 1 of the New Jersey Turnpike, and my annual goal is in a one-year period, I expect you to be at exit 12 of the New Jersey Turnpike. Again, very specific. I know where you are now, and I know where I want you to be in a one-year period. My short-term objectives might be that by December 15th, I expect you to be at exit 3 of the New Jersey Turnpike. Again, that's very specific. and it gives us the opportunity to gauge how that child is doing throughout the year, so that if by December 15th I'm in Delaware, you know that I'm going in the wrong direction, and maybe we need to revise the goals and objectives so that it's more in line with how the student learns and what the student needs to learn. If, on the other hand, I'm at or close to exit 3, then you know that the goals are working and the instruction is working, and that I'm learning what I need to, so that my IEP is going to provide that significant and meaningful educational benefit. The IEP also has other areas. It needs to talk about the strengths of the student, the academic development and functional needs of the student, the results of the evaluations conducted, and needs to set forth the performance on general state and district-wide testing. In case of a student whose behavior impedes his or her learning, you want to make sure that there's a behavior plan, or is going to take into consideration whether that child is exempt from the discipline code. It needs to take into consideration the communication needs of the student. We also need to make sure that assistive technology devices and services are made available if the student requires it. It also needs to detail accommodations that the IEP team determines necessary. And again, when we talk about an IEP team, that includes the parent. The parent is part of that IEP team. So if we're going to develop the IEP and make changes to the IEP itself, we can excuse members of the IEP team if everybody agrees. If the meeting deals with the excused members' areas, they have to provide written input to the parent and to the team in advance. If the parent and the local educational agency agree, you can make changes to the IEP after the annual IEP meeting by doing what we call an amendment. And an amendment is a written document that gets sent to the parent that outlines what the change to the IEP is. And as long as the parent signs that amendment and sends it back, the change to the IEP can be made without actually holding an IEP meeting. An IEP is supposed to be held annually, but can be held more often if necessary. There are students, because of their needs and their ever-changing needs, that we may hold an IEP conference more than once a year. I've had situations where we've held one every 8 weeks. That's the exception rather than the rule, but we can hold them, more often if needed. I should say that if a parent does not agree to the amendment and doesn't sign it, the IEP cannot go into effect. And that's the amendment part. An amendment must be signed by the parent. At the end of the IEP meeting, the parent has to be provided with a copy of the IEP or written notes setting forth the agreement with respect to the IEP as determined by the IEP team. And if agreement cannot be reached, the child study team must finalize the IEP, and then the parents are left with their rights with regard to whether that IEP is going to be implemented or not. A parent, and again, this is New Jersey, a parent only has to sign consent for the initial IEP. Thereafter, if an IEP is given to you at a meeting and you disagree with it, but you do nothing, or you send a letter to the director of special services or your case manager and you say, I disagree with this IEP. If nothing else happens, that IEP is going to go into effect 15 days after you get it. Doesn't matter that you objected to it. The only way to prevent an IEP, except an initial IEP, from going into effect is to file for mediation or due process within 15 days, or to get in writing from your school district that they agree to keep that IEP in draft form. So if you write a letter to the director of special services or your case manager and you say that you disagree and they say, okay, we're going to keep it in draft and we're going to hold another IEP meeting, you don't have to worry about it. But if you send a letter saying you disagree and they don't agree to keep it in draft, it's going to go into effect 15 days after you get it unless you take affirmative action to stop it. Always save your child's IEP and progress reports each year. Very, very, very important. It's amazing how many parents go back and look at the progress reports and realize that the goals and objectives haven't been changed, or that their child is functioning at the same level. So you want to make sure that you have all of those so that you can compare them from year to year. Remember, IEPs have to be reviewed at least once a year, but you can ask for an IEP meeting more often if necessary. So the next section I want to talk about is Section 504 of the Rehabilitation Act of 1973. And for purposes of Section 504, it is designed to prevent any form of discrimination for eligible students with a disability, and a parent or a student themselves can request accommodations to level the playing field for eligible students. So the difference between our 504 kids and our IEP kids is our IEP kids require special education, while our 504 kids require only accommodations and modifications. For purposes of Section 504, a disabled person is one who has a physical or mental impairment which substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. It's about the degree of impairment, not the diagnosis itself. So you want to make sure that you remember that. So what are major life activities? Communicating, thinking, learning is a major life activity, and that provides for reasonable accommodations and modifications to, again, level the playing field so that the child is on even footing. What are the factors that we look at in determining substantial limitation? We look at, does the impairment result in failure or underachievement when compared to their same aged non-disabled peers? Does the impairment impact a major life activity? Does the impairment last for at least 6 months? And will the impairment disappear without any intervention from the school? If we look at those factors and we answer yes to those questions, then the child could be eligible for reasonable accommodations and modifications under Section 504. So when we talk about examples of classroom 504 accommodations, tailoring homework assignments, changing the way a test is given, simplifying instructions, providing a copy of peer notes, supplementing verbal instructions, using behavior management techniques. These are all things that we can do. We also have, things like oral testing, use of a tape recorder, computer-aided instruction, providing nursing services to supervise administration of medication. These are meant to just be examples of types of things that we do that could be considered reasonable accommodations. What do we do if there's a disagreement about what's appropriate for the child? There are a variety of things that we can do. The first thing we can do is we can ask for an independent educational evaluation to see if somebody from the outside who's not working for the parent or the school district has some thoughts as to what the child requires. You can ask to meet with the child study team again to see if you can come up with some reasonable compromise that everybody can live with. You can request mediation, and that's through the State Department of Education. And in New Jersey, you can look through the New Jersey Administrative Code and the Parental Rights in Special Education, your prize book that they give you, and it'll tell you exactly how to go ahead and request mediation. You can file a complaint with the State Department, or you can request a due process hearing. These are all things that can be done to determine and help get rid of differences between you and the school district. So what are your rights as a parent? You have a right to be considered a full participating member of the IEP team planning for the child. You should be heard and you should be listened to. You have the right to provide information about your child that can be used in developing interventions, evaluation planning, and educational programs. You have the right to ensure that your written permission is given before any formal evaluations are begun. You have the right to receive written notice. You have the right to access your child's records and have someone available to explain those records if you request it. You have a right to a complete evaluation on special educations. The right to receive transportation and other related services necessary for your child to benefit from his or her special education and related services. You have the right to request mediation and due process. So let's talk a little bit about how you prepare to go into an IEP meeting. Always be prepared. Go into the IEP meeting knowing what you want. I always like to tell my clients to send a letter in advance of the IEP conference outlining the things that you'd like to station and be able to discuss things, because there's a difference between, excuse me, I have a little cold, advocating for your child and being adversarial. I always like to say you get more bees with honey than you do with vinegar. So go in, and if you state your case in a very objective way without yelling and screaming, you're going to get a lot further than if you go in ranting and raving. Don't be afraid to share information. I can't tell you how many times I have parents come into my office who have outside evaluations, who have outside tutors, and say to me, we didn't provide the district with any of this information. You want to give the district as much information as possible so that they can help meet your child's needs. Keeping that information to yourself doesn't help anybody. You want to make sure that they have all of the information so that they can meet the needs of your child. Remember that from the time you receive an IEP with which you disagree, and this is in New Jersey, you have 15 days to file for mediation or due process to invoke stay put. I always like to tell parents that, because a lot of parents come into my office and don't realize that just telling the district they disagree is enough. You need to file for due process or mediation to invoke that stay put. Experts. To convince a district to provide services or change a program or placement, a lot of times you need an expert. We as parents know our kids better than anyone, but professionals in the field want to hear from other professionals. So if you have outside professionals that you're working with who can write letters, who can provide outside testing, that's going to go a long way to teach or tell your school district that you have outside professionals who know what they're talking about, that say that a child needs a particular service. And finally, know your rights. Very, very, very important. Attend seminars and lectures like this. Join other Facebook groups and other parent groups. There are a lot of people out there with a lot of information to share, and it's a good way to meet people and to get a lot of information. I have, at least in New Jersey, and actually nationwide, listed a couple resources that are really great for parents. COPA is the Coalition of Parent Advocates and Attorneys, and they are a listing of advocates and attorneys that practice for parents across the nation. And there's a lot of good information on that website, not just about people that practice in the area, but what your rights are and things that you can be asking for. SPAN, www.spanadvocacy.org, is a statewide parent advocacy network that is across the states. You can go to your Department of Education, look at Facebook groups, parent support groups like the Tourette's Association or CHAD are all great organizations that can help you learn not only from experts in the area, but other parents who are very, very knowledgeable. And it's a good support group. I know when my kids were younger, I belonged to CHAD, and it was wonderful to talk to other parents who knew exactly what I was going through. So I think we're just about out of time. We're leaving some time for questions. So I want to thank you very much for listening to me. And if anybody's got some questions, I'm here to answer them.
Okay, thank you. And I will give you a minute to kind of catch your breath and maybe try a cough drop or something to ease that. So we do have a lot of questions. So how's the voice? Are you okay?
No, I'm good. Yes, I apologize for the cough. It came up today.
Yep, no apology necessary. I understand. Okay, so need a clarification about something. The question is, I always thought, I'm assuming this is an educator, I always thought that 504 plans gave accommodations, but not modifications. And the question says that I believe you said a 504 plan can give modifications. Is that correct?
Yes, it's reasonable accommodations and modifications, depending on how far those modifications go. You know, if we're providing, you know, a shortened test, well, a shortened test would be an accommodation, but I'm trying to think of a modification right now, but it can provide modifications. They're mostly, most of the time it is an accommodation, but modifications can be provided as well. It just can't go to the level of providing special education.
Okay, so you could then, you have an accommodation that needs to be tweaked, basically. So the modification would be to an accommodation that's already in place. Is that what you're saying?
Correct. So, for example, you know, an accommodation might be extra time on a test.
Right.
A modification might be that the student could give the test orally as compared to, you know, in written form, or only has to provide, you know, 3 answers instead of 4 answers. But they're going to be held to the same curriculum as everybody else. It's just accommodating or modifying so that it equals the playing field.
Okay, all right, thanks for the clarification. Do 504 plans have an ending date?
So a 504 plan is normally done for a 1-year period, just like an IEP would be done. And every year it has to be reauthorized.
Okay, so you would be looking to reauthorize that then at the end of the previous year or the beginning of the new school year?
It depends on the district that you're in. I have some districts that will do it at the end of the year, and we'll have some that do it in the beginning. I would prefer that it be reauthorized at the end of the year so that it's in place for the beginning of the next year, because sometimes what happens is a child will go from an elementary school to a middle school, and that 504 plan gets lost in the shuffle. So if the 504 plan is reauthorized, then the parent can take that 504 plan and take it to the new school and say, here's the 504 plan that we have, and you know, this is what you need to implement.
Okay, thanks. So if a child scores approached expectations on a PARCC, and I'm going to let you, I'm sure you know what that is, so for our audience, I'll let you explain what that is. So,
Right.
So if a child scores approached expectation on that test, is the district supposed to take specific remedial actions to try to bring the child up to a met expectation level?
So the district and the park is the standardized test that New Jersey was giving. And we've gone from, you know, the California Achievement Test, and we've had all different kinds of tests. The park was the latest that New Jersey was using. And it's only a snapshot in time. It's not the end all and be all. So what a school district is going to do is they're going to look at the results of the park testing, and they're going to also look at how the child has done in school, you know, where they are in the curriculum. They're going to look at the testing that the teachers have given, the rubrics, because each district has rubrics that they use in terms of math scores and written language scores and reading scores. They're going to take all of that into consideration to determine what kind of remediation, if anything, that a child needs. You know, speaking from personal experience, you know, one of my sisters, one of her kids, didn't score well on the park, but everywhere else he was doing beautifully in school. So she called the school and said, you know, what are we going to do to remediate this? And the school was able to sit her down and say, well, that was just one day and one snapshot. Here are the, you know, 72 things that the teacher had given during the year, which shows us that he actually was meeting expectations.
Okay. So that's a snapshot in time is a great way to explain that.
Correct.
Then. Thanks. Okay.
And that's the same thing with standardized testing as well. You know, even when we evaluate children, a lot of times we may get a high score or a low score, and it's different than what the teacher's getting within the classroom. And all of that needs to be taken into consideration to look at the total child.
Okay. So another educator with a question. I use the language of access for 504 versus success for IEP with parents, and that often helps to clarify the difference. And the question is that appropriate?
I think that's a very good way to talk about it. The access, you're absolutely right. You're providing access to their educational program, but you're also setting them up for success. So I agree with you with regard to the 504 plan, but I would make the argument that you're setting them up for success with that 504 plan as well.
Okay. I don't know if there'll be another comeback on that question, but okay. we'll leave it at that for now. So I have a question about behavioral accommodation and an example of what that might look like.
A behavioral accommodation might be if the child is, every time the child is asked to write something, he tries to crawl on the floor under the desk because he's frustrated. A behavioral accommodation might be that that child, you know, is permitted to take a walk if he can finish, you know, 2 sentences. Or a behavioral accommodation might be that if, you know, everybody else is required to participate in an activity for 15 minutes, the child may only be required to participate for 10 minutes. It runs the gamut depending on what the child's needs are.
And what the behavioral issue is, correct?
Correct.
Yeah.
Yes.
Okay. All right. Trying to paraphrase this a little bit. So how can we help educate the medical community about the process for determining the need for an IEP? Doctors who are prescribing, that's in quotes, IEPs, 504s, educational programs, etc., without collaborating with school professionals. So without any educational collaboration.
So there are 2 things that I see there. One is the physicians who are not referring parents to appropriate agencies and district personnel based on my child, you know, maybe struggling in school or having, you know, issues, to write letters saying different issues, but it's the same result, which is we're sort of, we have tried to do that in terms of going to some of these professional conferences, offices, but I think that it really, just like I always say, it comes down to training of teachers at college and what we're teaching our teachers. I think that it comes down to providing medical doctors with the same type of training and requiring them to take a course in, you know, evaluation and the law when it comes to students, because even, you know, regular pediatricians who are not, you know, developmental are going to come across kids that have IEPs, or that they should know you know, when to refer or not to refer. And I think that comes down to, you know, teaching in the schools.
Do you think it's in part possibly that, you know, that the pediatrician is being pressured to write something like, I need something for my kid, and then they're not completely sure either, but that's their patient, so they want to provide something.
Absolutely. And is functioning in school, and the doctor didn't reach out and find out exactly what's going on. That's the ask form, or the Connors rate it to the teachers to find out what the teacher's concerns are, if the teacher has concerns at all.
Okay,
and then
good
make
point.
an informed decision.
Good point. Thank you. Who determines how many and which tests will be provided to determine eligibility?
So that's supposed to be done by the IEP team collaboratively. And sometimes what will happen is we'll start with basic screening tools. So for example, if we're looking at the learning consultant and the evaluation the learning consultant is going to give, most learning consultants start with either the Woodcock-Johnson or the Weschler individual achievement test. And then based on, the results of those evaluations and where the child scored high or scored low, we should be delving deeper into, okay, where are the other areas that the child may really struggle? But it's supposed to be collaborative. So when we sit down and say, okay, we're going to be doing a speech and language, well, what areas do we see the child struggling with? Is it pragmatics? Is it semantic? It shouldn't be a cookie cutter, one size fits all. A lot of times I do see school districts saying, okay, well, we're going to give, the receptive one-word picture vocabulary test, and we're going to give the expressive one-word picture vocabulary test, and the parent doesn't know any better, but the child really doesn't have any receptive language issues. The child's issues are in pragmatics or semantics or, other areas. Maybe it's social, maybe it's executive functioning. So you want to make sure that it's the areas that you're seeing the child struggle in. And the parent has a lot of good information because they see the child at home and in different environments. So they can say, listen, I don't know what kind of test this is, but I know that my child has difficulty comprehending, or I know my child has difficulty with oral language or reading, decoding words, or, they're really impulsive. And based on that, excuse me, the team should then figure out what tests should be given.
Okay, take a breath, take a drink. Yeah, that's all right. I'm
sorry.
No pressure. No, don't apologize. I've been in that situation, and it's really uncomfortable.
One thing I did forget to mention, and I want to mention this because I think it's really, really important. One of the things that I used to do when my kids were young, and I've told all of my clients to do this, is what I call the cheat sheet for parents. When you have a child with a disability, you want to make sure that your child's teachers know who that child is. So what I always tell my clients to do is at the beginning of the year to come up with the 10 things you want your child's teacher to know most about your child, whether it's strengths or weaknesses or how he learns or things that they could be doing in the classroom, because your child is not the only child with issues that teacher has to deal with, especially when you get to middle school or high school. And a lot of times while they're supposed to be reading the IEP, some of them just glance over it. So you want to make sure that you reach out, tell them who you are, introduce yourself, and say, hey, these are the things that have worked really, really well in the past. I just wanted to bring them to your attention to give you a little heads up so that maybe we can, move up the learning curve a little bit.
Excellent. It's a great idea too. So what does it mean? Let me understand this. What does it meant for reauthorization? So the question's a little confused to me, but what it is what does it mean for reauthorization?
So every 5 years, Congress is supposed to sit down and look at the Individuals with Disabilities Education Act, and they're supposed to decide what they like about it, what they don't like about it, what changes they want to make, and then it's supposed to be reauthorized. Unfortunately, the last time it was reauthorized was in 2004. So we have not made any changes to the Individuals with Disabilities Education Act, and it's now actually the Individuals with Disabilities Education Improvement Act of 2004. That was the last time Congress actually looked at it.
That doesn't sound good, huh?
No.
Okay. What is IR plus S?
Oh, so that is intervention and referral service. So that's the precursor to having the child referred to the actual child study team. So it's intervention and referral services. That's where there's a group of people in the school that sit down, usually on a monthly basis, and students are brought to their attention, and they're supposed to put accommodations, modifications, and special education services in place prior to actually putting it into an IEP to see if with those additional supports, the child's functioning can improve so that we don't need to necessarily classify the student.
Okay, thank you for clarifying that. This is a question specific to New Jersey, but it's really a solid question. In terms of children with hearing loss in New Jersey, do you find one plan is better than the other? So I'm assuming 504 IEP here. Is there one that makes the most sense for hearing loss?
It depends on the child. Whether it's a 504, it used to be years ago that it was always an IEP was better than a 504 plan because people didn't know 504 plans and people weren't following them the way they should. That has changed. And I think that a 504 plan now has as much bite as an IEP. The positive about a 504, especially when you're in high school, is that an IEP ends the day the child turns 21, well, I should say June in the year the child turns 21, or when the child receives their high school diploma, whichever occurs first. So for most kids that are going on to college, they're going to graduate at 18 and they're going to go into college. If they have an IEP, that IEP then needs to be converted to a 504 plan because colleges don't follow IEPs, they follow 504s. If a child already has a 504 plan, you just hand that 504 plan to the college and you're good to go. With regard to hearing impairment, it's going to depend on what the child needs. If you're looking for a child to receive teacher of the deaf services, you're probably looking at, an IEP because it's a special education service. But if the child only requires reasonable accommodations and modifications, a 504 plan is going to be great. And in fact, I'm going through this with my niece right now because I do have a niece with a hearing impairment. And she had a learning disability as well. And we've remediated the learning disability to the point where now she really only needs accommodations and modifications. So we're talking about actually converting her from an IEP to a 504 plan.
Okay. Going to your comment that you just made about the IEP turning it into a 504. So who does a parent see about that? Does the school do that? And when would that process begin? You've got to allow time for that, correct?
Yes. So we can do one of two things. Sometimes colleges will allow you to take they'll just look at the testing that's been done. And as long as the testing has the reasonable accommodations that you're looking for, we might be able to do it that way. Otherwise, what you want to do is going into the senior year, probably no later than January, you want to sit down with your 504 team or your IEP team and say, listen, what I'd like to do is to take all the accommodations and modifications and put them into a 504 plan so I can just present that to the college.
Okay, so the school, your team at the school is the one that you should be doing that for you.
Absolutely.
Yeah, okay. All right, thank you. We're over time, but we have some more questions, but if your throat has had it, I'm willing to, to wrap it up here. You tell me how you're doing.
Let's do another 3. How's that?
Okay, another 3. In New Jersey, are parental requests written within the IEP enforceable?
No.
All right.
In order for a parent to request anything, but unless it is agreed upon by the team, it's not something that they have to do. So a lot of times the school district will say the parent has asked for one-on-one reading instruction 5 times a week with a level 1 certified Wilson instructor. The team does not feel this is necessary.
Okay, so you can make all the requests you want, but you've got to get
Correct.
their agreement to
Absolutely.
it. Okay. Are we, this is a parent, so are we entitled to receive the draft of the IEP before the meeting?
No. The reason I say that is because technically speaking, they're not supposed to be coming in to the IEP with a draft. Otherwise, it's considered predetermination. what a school district will normally do is come in with a draft and say, I just jotted down some ideas. These are just for discussion, but we can modify this any way we need to. But there's nothing in the New Jersey Administrative Code that requires the school district to provide you with a copy of that draft in advance. I will tell you there are some districts that do it, but it's not required.
Okay, but you still get some time to review it after you receive it, correct?
Absolutely. You have those 15 days. Absolutely.
Yeah, okay. And I think this next question, we'll wrap it up after this one, is a pretty timely one. So, and again, I don't know if this is a parent or an educator doing this. If they, I'm talking about the state here, if they remove rights to choose health interventions, for example, vaccine choice, and keep special ed children from school, do they lose their right to FAPE?
Yes. At that point, I shouldn't say that. I can't answer that question yet because I don't know what they're going to do if they take away, and I know New York has done this. If you're not vaccinated, you can't attend New York schools. New Jersey hasn't done that yet, but if New Jersey were to do that, I don't know whether our legislature would put something in into our code talking about students who are not vaccinated who receive special education. Does the school district have to provide alternative services? I can't answer that question right now because I don't know what they're going to write into the law.
Okay, and we're not even sure that they're going to do anything about it then in New Jersey, correct? Okay.
Correct.
All right, then I promise that was the last one. There are many more questions, so I'll let Kelly talk about how that's going to get handled. But we have just had a really wonderful turnout tonight and really great questions. So I'm going to wrap this up here. Thank you so much, Staci. It was a really great presentation, and turn this over to Kelly for a wrap up.
Thank you.
Thank you for joining our webinar on IDEA and Section 504, What Every Parent Needs to Know. There is an exit survey which we need everyone attending to fill out. The webinar blog is open now and available for the next 7 days on the NJCTS website for any additional questions that were not covered in tonight's presentation. All questions that we did not answer tonight will be posted to that website. This website, you can reach the blog through our website, www.njcts.org. Also, an archived recording of tonight's webinar will be posted shortly. Our next presentation, I Wasn't Aware, Brain Function and Why Do We Have a Brain, will be presented by Dr. Vincent Kieshland and is scheduled for December 4th, 2019. This ends tonight's webinar. Thank you, Ms. Greenwald, for your presentation, and thank you, everyone, for attending. Good night.